The Election Petition Tribunal sitting at the Court of Appeal, Abuja, has summoned the whole parties involved in this presidential election petition seeking to disqualify Bola Ahmed Tinubu as the president of Nigeria. The whole parties involved have been summoned to adopt their addresses. After that, the tribunal is going to fix the date for the judgment. Reminding you that last week, Bola Ahmed Tinubu wrote to the tribunal in his final address, asking the tribunal to conduct a rerun election, excluding the presidential candidate of the Labour Party, Mr. Peter Obi. Now, Mr. Peter Obi also has told tribunal in his address earlier that Tinubu is not qualified if there will be anything like rerun election, that Tinubu must be excluded. And it is developing that few weeks or few days to come, the tribunal may be passing out the judgment about these petitions. What and how will they look like? This video has the details.
President Bola Tinubu has appealed to justices of the Presidential Election Petition Court in Abuja to exclude the presidential candidate of the Labour Party, LP, Mr. Peter Obi, and his party in the event of any rerun presidential election, claiming that only him and the candidate of the People's Democratic Party, PDP, Alhaji Atiku Abubakar, are constitutionally qualified to recontest. Tinubu argued that Obi and his party will not be qualified to recontest if the justices void the February 25, 2023 presidential election. But Obi urged the five-member panel not to subvert the people's will as expressed in the February 25 presidential election, stressing that President Tinubu should be sacked without further delay. Tinubu faulted both Obi and the Labour Party for asking the court to cancel the election and compel the Independent National Electoral Commission (INEC) to conduct a fresh poll in which he, Tinubu, Shettima and the All Progressives Congress (APC) would not participate. He argued that should the relief be granted, Obi and LP would not derive any benefit, having been constitutionally barred from contesting the rerun election. President Tinubu's submissions were contained in his final written address in response to the petition of Obi and the LP, challenging his declaration as president. The chairman of INEC, Professor Mahmood Yakubu, had on March 1 declared Tinubu the winner of the February 25 presidential election with 8,794,726 votes, while Atiku and Obi reportedly scored 6,984,520 votes and 6,101,533 votes respectively. While citing alleged issues of substantial non-compliance with electoral laws, corrupt practices, and non-qualification amongst others, Obi and LP on the one hand, as well as Atiku and the PDP on the other hand, had in their petitions asked the court to nullify the election. Alternately, they urged the court to order a rerun election to decide the authentic winner of the poll. In his final written address to the petition by Obi and the Labour Party, which Tinubu filed through his lawyer, Chief Wole Olanipekun, SAN, he submitted that the evidence tendered by the petitioners failed to prove claims of non-compliance and corruption capable of voiding his election. He, however, added that in the very unlikely event that the election of February 25, 2023 is voided, the candidates constitutionally prescribed to contest any subsequent election shall be the second respondent and the candidate of the PDP who came second by scoring the next majority of votes in the highest number of states, 19 states, to the first petitioner's 16 states, and also coming second by plurality of votes, having scored 6,984,520 votes, far and above first petitioner's 6,101,533 votes. In effect, the petitioners have no locus standi to ask for relief to, both constitutionally and legally. Constitutionally because he is barred from contesting, legally because he has no benefit to derive from the said relief, assuming it is granted. Contending that the court cannot decree an order for a fresh election outside the provisions of the Constitution, Olanipekun, who cited a plethora of authorities, said the law is settled that a party prosecuting an action would only have locus standi where the reliefs claimed would confer some benefits on such a party. Section 134, subsection 3 provides thus: in default of a candidate duly elected in accordance with subsection 2 of this section, there shall be a second election in accordance with subsection 4 of this section, at which the only candidate shall be A. the candidate who scored the highest number of votes at any election held in accordance with the said subsection 2 of this section, and B. one among the remaining candidates who has a majority of votes in the highest number of states. However, that where there are more than one candidate with majority of votes in the highest number of states, the candidate among them with the highest total number of votes cast at the election shall be the second candidate for the election. The learned Silk drew the court's attention to the testimony of INEC's sole witness, who observed that Obi's name was nowhere in the party's register, Exhibit RA18, before he became the presidential candidate. He added, in any event, the first petitioner has failed to comply with the law of the land by first making himself a member of the second petitioner before proceeding to purportedly contest the election and even file a petition. We again refer to the uncontradicted evidence of the respondent's sole witness, who observed that the name of the first petitioner is nowhere located in Exhibit RA18. Arising from the foregoing is the fact that the petition is improperly constituted, and as such, at the end of evidence and trial, it is clear that it does not vest jurisdiction in this honorable court to entertain it, and more particularly, to grant the relief sought. The essence of all this is that in the absence of the PDP and its candidate, the NNPP and its candidate, the grounds of the petition, the paragraphs making allegation against the parties, and any evidence extracted during trial becomes incompetent and inadmissible in the absence of those parties. On the other hand, Peter Obi, the Labour Party presidential candidate, has urged the 5-member panel of the Election Petition Court not to subvert the people's will as expressed in the February 25 presidential election. In his final written address in support of his petition, Obi challenged the declaration of Senator Bola Tinubu as the winner of the presidential poll and urged the panel to sack the president. He reminded the panel that its powers of adjudication, as provided in the Nigerian Constitution, were freely donated to them by the people. Hence, they need to uphold the confidence reposed in them.